Hello and welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Jennifer Leonard. Today, we're pleased to be speaking with Stephen Burbank, the David Berger Professor of Administration of Justice here at Penn Law, and with Sean Farhang, a Professor of Law and Associate Professor of Public Policy and Political Science at the University of California, Berkeley. We'll be speaking with the professors about their new book, Rights and Retrenchment, The Counter-Revolution Against Federal Litigation, just out from Cambridge University Press. Let's get started. Sean, I'd like to start with you. Could you tell us what is private enforcement and why does it matter?
Private enforcement, the book focuses on private enforcement of legislation particularly. And when Congress chooses to regulate in some fashion, to order someone to do something or not do something in a civil rights law or an environmental law, for example, it has to make a choice about how the laws are going to be implemented. It can allow private individuals who have grievances under the law to enforce it. It can create administrative machinery, an agency, for example, and empower the agency to implement it, or it can create a hybrid regime of both public and private enforcement. Our book focuses on private enforcement, and some important context for it is that there was a significant growth in Congress's reliance on private enforcement beginning in the late 1960s. And one important reason that Congress increasingly relied on private lawsuits to implement legislation was that it came increasingly to distrust the executive branch. Growing ideological conflict between Congress and the president led Congress increasingly to rely upon private enforcement as a kind of insurance policy against under-enforcement by the executive branch. It may be worth noting that it's in some sense bipartisan in that Republicans, like Democrats, rely upon private enforcement, so people tend to think about it as this democratic phenomenon. But in examples, for example, there are examples of Congress giving employers private rights to sue unions or giving people private rights of action against protesters at the funerals of service members. So it plays out with both kind of liberal and conservative purposes.
So, Steve, could you talk a little bit about the Civil Rights Act of 1964 and why that was so important in the context of private enforcement?
Yes. Liberal interest groups and members of Congress had favored enforcement of the Civil Rights Act of 1964 by a public entity on the model of the National Labor Relations Board, and they were disappointed that didn't happen. However, they were surprised and very pleased when it turned out that private enforcement of the employment Title VII, proved very successful, and that experience also told them that a major reason for that success was that the opportunity to gain attorney's fees if you prevailed created a robust private bar. And as a result of that experience, liberal interest groups and members of Congress replicated the model in many other regulatory statutes that were passed in the late 1960s and 1970s, especially perhaps most prominently of which was the Attorneys Fee Awards Act of 1976, which made attorneys' fees available to prevailing parties in litigation under all of the Civil Rights Acts.
I'll add a quick irony to the story that Steve just told, and that is that the Democrats were unable to pass the Civil Rights Act without significant support from moderate Republicans because the party was divided, with the Southern Democrats opposed to the Civil Rights Act. And it was actually the moderate Republicans in a pivotal position to block the legislation that, as a condition of its passage, eliminated the agency powers that had been in the statute and created a private right to sue, seeing it perhaps as the lesser of two evils. I say ironic only in the sense that that private right of action in Title VII that was inserted by Republicans to defeat kind of the growth of the administrative state wound up being one of the most productive private rights of action of any statute in American history in terms of the volume of litigation that it generated, and became the model that was replicated in many other policy areas and adopted in many other policy areas.
A very good example of watch what you wish for.
That's right. So, Sean, could you talk a little bit about why there was such pushback against it and what some of the strategies were of the movement against private enforcement?
The pushback against it, we find in the book, began very clearly in the first Reagan administration. As many have observed, a deregulatory program was a key part of the first Reagan administration. And more conservative people within the administration recognized that as they sought to roll back the role of the administrative state as a regulator. In order for the deregulatory project to succeed, they also needed to curtail private enforcement so that it didn't just flow in and fill the spaces left by withdrawn administrative power. These conservatives within the administration, who are important actors in the developing conservative legal movement, they had witnessed the dramatic growth of private enforcement over since the enactment of the Civil Rights Act in 1964, but particularly in the 1970s. And seeing this dramatic growth, in some sense, they were responding to that dramatic growth, trying to turn it back as part of the wider deregulatory project of the Reagan administration. It's interesting, kind of as a historical note, that one important actor in the Reagan administration at that time who was advocating this agenda of retrenchment was now Chief Justice John Roberts.
I just want to point out that this movement legislatively to diminish incentives for private enforcement was one part, only one element of a much broader strategy, which they called defunding the left. Another prominent element of that strategy was to either abolish or radically reduce the funding of the Legal Services Corporation, which provides essentially the only civil legal aid we have in this country.
What impact did legislative efforts to push back on private enforcement have?
Well, in order to look at legislative impact, we collected data on bills that sought to amend existing federal law to limit incentives and opportunities to prosecute lawsuits by plaintiffs over a range of issues that we think are important. We wound up with about 500 bills in the data set, and that spanned 1973 to 2014. And we observed that of them, there were only 11 of those bills were passed, but more importantly than the small number that were passed, only 3 of the bills could be regarded as consequential. So the movement, we show there was significant bill activity. They sought this to retrench private enforcement by amending legislation, and they substantially failed. And thinking about why and studying the kind of archival records surrounding the Reagan administration, we observe a couple of things. One is that it's just one explanation for the failure is that it's extremely hard to take away existing rights. Political scientists have shown that people are much more likely to mobilize against politicians and vote against politicians when those politicians try to take something they have from them. And as a result of that, the political dangers of retrenchment, the moderate Republicans failed to join the more conservative elements of the party that were pushing this agenda, and they were unable to get it through.
And I think it's useful to spend a minute on the 3 bills that we regard as consequential that were enacted. One of them concerned prisoner litigation, and prisoners, of course, don't have much power in the legislative process. The other 2 successes were enacted only after years of effort, and they elicited vetoes and filibusters. And one of them, the Private Securities Litigation Reform Act, affected litigation in only one substantive area. And Professor John Coffey of Columbia, who's probably the leading scholar in the area, concludes that at the end of the day, it didn't really change much. The third successful bill, the Class Action Fairness Act of 2005, had the purpose and effect of bringing most large state law class actions into federal court, where they would be subject to an increasingly conservative jurisprudence. And it's interesting to us because it indicates pretty clearly that the members of Congress who fought so hard over years for and against this legislation realized that it would bring these cases into the courts, where, of course, years before, the architects of the counter-revolution in the Reagan administration had realized that if the campaign was going to be successful, it was going to be successful in court.
What impact did federal rulemaking have? Could you explain a little bit about that?
And try. In 1934, Congress delegated to the Supreme Court legislative power to make prospective legislation-like rules of procedure with the limit that they not affect substantive rights. The original Federal Rules of Civil Procedure, which became effective in 1938, radically changed the infrastructure of federal litigation by purposefully making it much easier for plaintiffs to state a claim, and by making available to all of the parties radically increased means of getting information from the other party. That's called discovery. Amendments to the federal rules that were made in the 1960s enhanced its potential to advance private enforcement, most notably through the creation of the modern class action in Rule 23, which has made it possible for groups who have been injured in similar ways to band together and sue. The huge increase in federal litigation that Sean has mentioned that started in the late 60s and continued into the 70s and 80s, which was partially the result of these amendments to the federal rules, including particularly the class action rule, prompted grave concern in the leaders of the federal judiciary. And a new Chief Justice, Warren Burger, used the occasion of reconstituting the drafting committee for the rules, the advisory committee on civil rules, to express his hope that they would be able to come up with amendments that would lead to major changes with the potential to cut back on federal litigation.
So yeah, I'll add to what Steve said by saying a little bit about the empirical work that we did in that chapter on rulemaking. What we found was that the Chief Justices, all of whom have been Republican-appointed Chief Justices, since 1971, we find that they have very, very disproportionately appointed Republican federal judges to staff the advisory committee that makes the federal rules, and have disproportionately appointed corporate attorneys, and in recent years, corporate defense attorneys to that committee. However, we observed that despite the obvious stacking of the committee in some sense by Chief Justices, that a relatively small percentage of the rule proposals by the committee have actually been salient to private enforcement. And of those that have been salient to private enforcement, the retrenchment successes have been fairly modest and episodic. And we try to think in the chapter about why that is the case. And I'd highlight two things here. One, when kind of more aggressive initial retrenchment efforts by the Rules Committee began, there was a significant congressional response by Democratic Congresses that ultimately led to amending the Rules Enabling Act and reforming the process of rulemaking in ways that made it more open, more public, more transparent, and ultimately stickier, making retrenchment more difficult. And in addition, we believe that rulemakers learned something from that experience, and that made them somewhat more timid in future efforts at retrenchment. And that is that they did not want to provoke further congressional response that would diminish the judiciary's autonomy in creating rules within its own domain.
Okay, thank you. And how and why was the campaign in the courts so successful?
I'll start off on that question and say, first, in order to characterize the motivation for turning to the courts, we, in our chapter on Congress or on legislation, including the Reagan administration, we observed that some of the key actors who were disappointed in the failure of the effort to engage in retrenchment legislatively very self-consciously and strategically turned to the courts as an alternative pathway to achieve through the interpretation of law and rule by court what they had been unable to achieve through legislative amendment. In order to study this, we collect a large body of decisions by the Supreme Court on a wide range of issues that we think are important to private enforcement from 1960 to 2014. And we find that while the court was becoming increasingly pro-enforcement in the 1960s, and around the early 1970s, just when the conservatives achieved a majority on the court, there was a long decline in an increasingly low probability of success for plaintiffs seeking access to courts in our decisions. By the end of the period, in the body of cases with at least one dissenting vote, remarkably, the conservative 5 were voting against private enforcement 90% of the time, and nearly 90% of the time they were achieving an anti-enforcement case outcome. The question arises for us why the court was successful where Congress and the rulemakers were not. And we identify a number of issues. I would just highlight two that we think are most important, particularly important. One of them is that the court is free of the kind of democratic constraints and pressures that made it very hard for Congress to retrench, as we discussed earlier. It also limited the role of rulemaking in retrenchment. And another key idea that we explore is that the court's ability to characterize these issues as extremely technical and legalistic in ways that kind of obscured their relevance, led to low levels of media attention and therefore low levels of public knowledge about what the court was doing.
Actually, I mean, and we test that in chapter 5 of the book by taking a random sample of our private enforcement issues and a random sample of merits issues and tracking the coverage of those cases in the Times, the Wall Street Journal, and the Washington Post. And we find that our hypothesis is supported because the newspapers cover merits issues vastly more often than they cover the private enforcement issues. Therefore, the private enforcement issues really do fly beneath the radar screen. The public doesn't become aware of them. The Supreme Court knows it has a freedom of movement with respect to these issues that it doesn't have on the merits, and it can accomplish the same results.
So Steve, I've heard you say that procedure is power. Can we talk a little bit about what that means and why it's relevant here?
Sure. For at least a century, those who were seeking to gain or to retain the control of procedural lawmaking would refer to procedure as adjective law, or the handmaid of the substantive law, or describe it as technical or details, and it should be left to the experts. And that rhetoric was, in fact, part of the campaign, the successful campaign for passage of the Rules Enabling Act of 1934, and it helped the judiciary to retain a virtual monopoly of lawmaking power in this area for decades thereafter. Eventually, the legal realist insight that there's no bright line between procedure and substantive rights, which the people who sought judicial primacy had relied on, came back to bite them because scholars in Congress came to understand that if you leave to the judiciary choices between policies that are their special domain and policies underlying legislation, they're going to choose the policies that are their special domain, and Congress is going to lose. The three rulemaking proposals that were the source of the backlash that Sean described in the early 80s well illustrate this. I'll just refer to one set which did not become effective, and they would have amended a rule that concerns offers of judgment and is designed to stimulate settlement by imposing a penalty on somebody who doesn't gain a judgment that's greater than the last offer made by the opponent. The changes that they would have made to that rule would have essentially reversed the American rule on attorney's fees, which is that each side bears its own attorney's fees. But more important and of greater concern to members of Congress, it would have subverted all of the one-way fee shifting statutes that we talked about as a major tool of congressional advancement of private enforcement. So the dramatic impact of procedure on substance couldn't have been clearer, and it led to that backlash.
Procedure as power is also particularly useful, and I would say maybe particularly aided by the kind of more legalistic and technical quality of procedural rulings by the Supreme Court that, because of the fact that they have the lower visibility, as Steve was just describing, give the court greater latitude to be able to, in some sense, make the decisions that it wants politically without risk to compromising institutional legitimacy. And on procedure as power, I always can't help but quote the famous Representative Dingle, who remarked that I'll let you write the substance and you let me write the procedure and I'll screw you every time. And if that proposition is true, which I think most procedural scholars think that it is true, then part of, I think, what our book is suggesting is that it is the court who's writing the procedure. I'll leave it to others to judge whether anyone's getting screwed. It's the court that's writing the procedure, and it's doing so in a way that is receiving enormously little attention.
So with all of that said, what are your views of the future of private enforcement and federal rights?
I think you can approach that question by thinking about what's the future of the counter-revolution. We've shown how difficult it is, or has been, to retrench rights legislatively by attacking private enforcement. Retrenchment bills didn't pass largely, and they became vanishingly rare in the last 10 years or so. But with the 2016 election, the House passed a number of bills that could be deemed to be the Chamber of Commerce wish list with respect to class actions, further crippling the class action and restoring the 1983 version of Rule 11. Those passed in the House. I don't think there were hearings held on them. They haven't gone anywhere yet in the Senate. And if the Senate decides to turn to them, it will be another test of the proposition that clearly is confirmed by our data, namely that it's very, very, very difficult legislatively to retrench, even when you have unified government, even when Congress and the presidency are controlled by the same party. With respect to rulemaking, as we note in the book, there were 2015 amendments to the discovery rules that can be seen as an exception to our general conclusion that success in the rulemaking area was modest and episodic. Certainly Chief Justice Roberts, and remember, he's now Chief Justice of the United States, but he was once in the Justice Department and a main promoter of legislative retrenchment in the Reagan administration. Chief Justice Roberts devoted his entire annual report on the judiciary in 2015 to these discovery amendments, which he said were a big deal. Now, scholars disagree about whether he was attempting to spin them and to persuade people that they're a big deal when they shouldn't be, or whether he was in fact sort of drawing the veil off and revealing the truth of what some critics had feared, namely that the promoters of these rules were selling a wolf in sheep's clothing. Finally, with respect to the court, those who favor robust private enforcement have little to be optimistic about for the immediate future. And in this sense, as in so many others, the longer-term future probably depends on the health of a few liberal justices and on the 2020 presidential election. That said, it may make a difference if the public were aware of our findings and the implications of our work for democratic values, because in a series of cases over more than 40 years, the court has been chipping away at the infrastructure of private enforcement, confident that because the issues are perceived as technical and legalistic, the media will not report on them and the public will not be aware that they're losing their rights.
Anything to add?
I think that's a perfect place to end it.
Wonderful. Well, thank you, Professors Burbank and Farhang, for educating us about this really important topic. And thank you for joining us on this episode of Case in Point.